So today I will discuss the obligation of the debtor or obligor. So debtor or obligor is legally contractually obliged to provide benefit. Or ito yung mga obligado na magbayad or magsaoli ng kanilang hiniram. So sinabi pa dito, contractually bound to make all principal repayments and interest payments on outstanding debt. So, let's say sa kasulatan ninyong dalawa, kada buwan may tutubo na 5% sa utang mo. So, obligado ka na magbayad ng 5% na iyon. So, obligation of the debtor or obligor is determined in four ways. Obligation to give a specific or determinate thing. Or ito yung obligasyon na may tinutukoy talaga. May tiyak na tinutukoy. Let's say for example, you are obliged to deliver a Honda Civic car with model 2020 ABC with a color white. So, dapat yung dumating sa iyo is Honda Civic. Then, yung color niya is white. So, dapat yun yung dumating kasi yun yung request mo. So, number 2, obligation to give a generic or indeterminate thing. Or ito naman na obligasyon, walang tiyak na tinutukoy. Walang tiyak na tinutukoy. Let's say for example, nagpa-deliver ka ng isang sakong bigas. Pero sa isang sakong bigas na iyon is wala kang sinabi na sinandomeng or NFA or what. Then, sa pangatlo naman, may obligasyon din na sa pangatlo is obligation to do or yung mga obligasyon na dapat gawin ng mga obligor. So, obligado sila na magbayad or magsaoli ng kanilang hiniram or utang. Then, they are obligado sila para mag-appear sa hearing ng court if in case na magkademandahan. Then obligado sila para sagutin ang iyong mga katanungan. Then number 4, obligation not to do. Syempre may mga obligasyon din sila na hindi dapat nila gawin kasi nga may karapatang pantao. Hindi porket nangutang ka, wala ka nang wala ka nang karapatan. So, let's say for example, yung obligee is dinemanda ka. So, nag-file siya ng hearing, then na-receive mo yung summon, pero may kasunduan kayo na sa darating na buwan ikaw ay magbabayad. Pero sa araw na ito, na-receive mo yung summon, then you don't have the right para mag-appear sa hearing na yon kasi nga may kasunduan na kayo.
Good afternoon, ma'am. Good afternoon, classmates. I will be tackle about the duties of debtor or obligor in obligation to give a specific or determinate thing. It has 5 duties of the obligor, but I will be tackle the 3 only. Which is the number 1 to deliver the thing, number 2 to take care the thing before delivery, and number 3 to deliver the fruit of the things. First, I will explain the specific or determinate thing. The etiquette BG kasangkoma real obligation, which is your obligation to give. So specific or determinate thing get physically segregated. So, according to Article 1163, every person obliged to give something is also obliged to take care of it with proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Example of this real obligation or the specific thing is, kaslang kuma, Ma'am Regina bound himself to deliver her only dog to me. So, apay nga makon ko natin nga specific thing because the word nga only dog. Another example ket kasang kumasyak renegalwak ko man ni papang kuti lugan which is at the plate number na nga 143. So, makon ko na nga specific thing kasi word nga IG plate na nga 143. Syempre, awan ti kapada na nga plate numberen which is na segregate suna according to his class. No kan? So, number 1 duties of the obliger is to deliver the thing. Syempre, at the obligation na nga mang-deliver ka nga thing ka nagibagaan na nga tao. Number 2 is to take care of the thing before delivery. So, the debtor or obliger must preserve the thing. So, dapat ay bago nga i-deliver ka nga specific thing dapat alagaam. Syempre, no maawan or naperdi, awanti i-deliver mon. Kasi, hamo nga masukatan kasi specific thing. Unlike ka generic thing nga, kasang ko example ko tatay ket ko na only dog. So, dati ko generic ket Ma'am Regina bound himself to deliver a dog to me. So, awan word na nga only, so mabalin lata nga urean na nga dog i-deliver na. In case man nga naawan dapat nga i-deliver na. So, sa paanong pag-iingat dapat? So, in Article 1163, in general rule, the debtor must exercise the diligence of a good father of the family, unless the law or stipulation regulates difference its standard of care. So, maliban na lamang kung ang nakasaad sa kansunduan ay iba, kung may hinihinging standard diligence ang batas. Number 3 is to deliver the fruits of the thing. So, dati kun na nga fruits dito nga literal talaga nga fruits nga kasang kuma apple, orange, kazay, haan. So, in Article 1164, it says that the creditor has a right to the fruits of the family from time the obligation to deliver it arises. However, he shall require no real right over it until the same has been delivered to him. Example ket kasang kuma siyak nagpautang na karubami. So tatan inikak ti interest na, which is dati makon ko na nga fruits interest na utang na. So as mentioned by law, the fruits can be referred to natural, industrial, and civil. Letter A is the natural fruits, the spontaneous product of the soil and the young and other products of animals. Spontaneous product means inaramid nga awan ti intention na, no human labor involved. Example ket digji kumaruot or digji grass nga kusalata nga agtubtubon. Letter B is the industrial fruits, that's produced by lands of any kind through cultivation or labor. So, example dito iket kasang kuma daga nga dati agtubtubong halaman. So, it is considered nga fruits no kadijayan. The last one is civil fruits, which derive by virtue or juridical relation. Example met dito ket kasang kuma the apartments mo. Tatan, ti fruits met no kadijay ket tigijay renta nga agap po inti tenants mo. Kasla ta example comment tatay nga siyak nagpautang na tatan, di utang na inikak ti interest na.
Good afternoon everyone. So here's the continuation of the duties of debtor or obligor in obligation to give a specific determinating. So in number 4, it says to deliver accessions and accessories, which is Article 1166. In Article 1166, it tackles the obligation to give a determinate thing, which includes the accessions and accessories, even though hindi yun nabanggit sa hindi yun nabanggit sa kasunduan. Yun po yung Article 1166. Now, let's give the definition of accessions and accessory. First, we have the accessions. It says the fruits of a thing or addition to or improvement apan ating. So sinasabi di ibagbaga na ticket kas lang amin nga na-produce ni by a thing, it's either incorporated or attached, mabalin isuna nga naturally or artificially, which includes the fruit of thing. Example ket um, bahay na nabiling lupa or aircon ng isang car. Another example pa ket kas lang ko ma-shock, nagpromise na kanyam nga ikang katidog, which is inton June, itad ko kanyam ton June, ngem kadija in bagak nga bulan ket naganak di aso. So kailangan, so basically anak ti aso ket han nga i-mention di agreement ta, so kailangan ag-decide ti both parties no kadija aso, anak di aso ket no either maited tuba or haan kas lang kadjay. Tapos next ket the accessories. It says things joints or include with the principal thing for the latter's embellishment, better use or completion. So an example of this ket di tulbek ti balay or kotse. Syempre awmet lang serserbi na ti di balay wenno kotse no awmet lang di tulbek na. So that's accessories. Another example is bracelet of a wristwatch, DJT accessories. So basically accessories accessions, they are attachment to the principal thing that must be delivered by obligor. Yun yung accessions and accessories. Next, number 5, to pay damage if guilty of fraud, negligence, delay, or contravention of the terms of the obligation, which is Article 1170. This means that those whose in the performance of this I mentioned a while back will be grounds of liability, and if they find guilty, they have to pay the liable for damages. That is number 5.
Duties of debtor obligor in obligation to give a general indeterminating. Number 1. To deliver the thing. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. Article 1167. If a person is obliged to do something fails to do it, the same shall be executed at his cost. Kumbaga, itong patakaran na ito ay kailangan tuparin kung taliwas ang paggawa ng bagay na ito sa napagkasunduan. Ganon din kung ang paggawa ng bagay na ito ay hindi ayon sa nakapagsunduang pamantayan, ito ay maaaring ipabawi o ipagiba. Number 2. To bear the expense of having someone else comply with the obligation. Article 1165, paragraph 2. Article 1165. When it is to be delivered is determining the creditor in addition to the right granted him by Article 1170 may compel the debtor to make the delivery. If the thing indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has affected the delivery.
That those guilty of fraud, delay, or negligence in the performance of their obligations, or those who in any way contravenes the tenor of their obligations can be held liable for damages. Next, breaches of obligation. First, fraud, dolo. The fraud contemplated by foregoing provision is the deliberate and international evasion of the normal fulfillment of obligations. Next, negligence, culpa. Fault or negligence of the debtor as an incident in the fulfillment of an existing obligation. Third, last, delay. Delay in the fulfillment of the obligation. The delay, however, must be imputable to the debtor, obligors, and those who any manners contravene the tenor thereof, cover any illicit act which impaired the strict and faithful fulfillment of the obligation. Example, in contracts and quasi-contracts, the damages of which of obligor who acted in good faith is liable shall be those that are the natural and probable consequences of the breach of obligation and which the parties have foreseen or would have reasonably foreseen at the time obligation was constituted. In case of fraud, bad faith, malice, or wanton attitude, the obligor shall be responsible of all damages which may be reasonably attributed of the non-performance of the obligations.
The definition of an obligation is someone is required to do. An example of obligation is for a student to turn in his homework on time every day. A moral or legal duty to perform or to not to perform some action. Article 117. Kung ang tao ay obligado na gumawa ng isang bagay at hindi niya nagawa ito and paggawa o pagkumpleto nito ay maipapataw sa kanya. Itong patakaran na ito kailangang tuparin kung taliwas ang paggawa ng bagay na ito sa nakapagkasundo. Ganon din kung ang paggawa ng bagay na ito ay hindi ayon sa napagkasunduang pamantayan, ito ay maaaring ipabawi o ipagiba. If a person obliged to do something fails to do it, the same shall be executed at his cost. This time rule shall be observed if he does it of contravention obligation. Furthermore, it may be decreed that what has been poorly done by but there are the three situations. These are that debtor fails to perform what to do. For example, pag yung debtor hindi niya nagawa yung kanyang obligation, yun yung magko-contemplates. And second, it is to perform an obligation to do but contrary to the terms thereof. Gaya na sinabi ko kanina, yung debtor natin na nauna, pero ngayon yung pangalawa, nag-perform siya, meron siyang nagkaso, may pagkukulang siya pero hindi siya naaayon sa kausapan nila. At yung ay perform an obligation to do but in a poor manner. It means nag-perform siya ng kanyang obligation ayon sa mga napag-uusap.
Article 1167 refers to an obligation to do, to perform an act, or render a service. It contemplates three situations where the debtor fails to perform an obligation to do, perform obligation to do, but contrary to the terms, and perform an obligation to do, but in a poor manner. Here are the remedies of creditor in a positive personal obligation. If the debtor fails to comply with his obligation to do, the creditor has the right to have the obligation performed by himself or by another, unless consideration are involved at the debtor expense, and to recover damage in a case the obligation is done contravention of the terms of the same or poorly done, the court may order upon complaint that be undone if it is still possible to undo what was done. Article 1170 of the Civil Code states that those quality of fraud, delay, or negligence is the performance of their obligation or those who in any way contravene the tenor of the obligation can be held liable for damage. Fraud is an intentionally deceptive action designed to provide the perpetrator with an unlawful gain or to deny a right to a victim. Negligence, a situation which a person act in a careless way, manner which result in someone else getting hurt or property being damaged. Delay is the failure to perform an obligation on time which failure constitute a breach of obligation.
Naimbag na daw yu amin, ti pagsasaritaan ti tatakit, ti upad nga essential, ti obligation, ngem itakel ko lang tatakit kay duwa, which is passive subject and active subject. Ngem before tayo nga mapanidjay, upat, nga i-discuss ko pala muna ni Civil Code definition. The Civil Code defines obligation in its passive form in Article 1156 when it comes to responsibility as a legal requirement, juridical necessity. Our law simply emphasize the debtors or obligor, the who has the duty of giving, doing or not doing. Duty obligation is a juridical necessity because in case of non-compliance, the courts of justice may be called upon by a aggrieved party to enforce its fulfillment or in default thereof the economic value that it represents. In a proper case, the debtor or obligor may also be made liable for damages which represent the sum of money given as compensation for injury or harm suffered by the creditor or obligee, he who has the right to the performance of the obligation. For the violation of his rights, in other words, whether the debtor likes it or not, he must meet his obligation, otherwise, his failures will result in any negative or unfavorable consequences. People may violate obligations with impunity if they are not considered enforceable. However, there are certain commitments that cannot be upheld because they are not legally enforceable. So, itakal tayo the four essential of an obligation, but I will tackle the passive and the active subject. Passive subject called debtor or obligor. The person bound to perform or to pay. He is the one against whom the obligation can be demanded. He is also called obligor or the debtor. As lang, so tawag natin, agbaon. So, ada responsibility na, tiikan na. Tapos, ni active subject. Active subject, it is the party called creditor or obligee who has the right to demand the performance of an obligation. He is also called the obligee or the creditor. I'll give one example. Taman maawatan daypay. Here is the example that could help you to distinguish the elements. Sam is obligated to give Grace a diamond ring on May 1, 2022, pursuant to a contract executed on April 20, 2022. So, sino ti active ken sino ni passive? Ti passive tayo ket ni Sam. Sam is the passive subject or obligor. His performance of obligation is demandable. Sino met ni active tayo, which is si Grace. Grace is the active subject or obligee. She has the right to demand performance of the obligation. Nawatan tayo guys. So, ni Sam, iti passive subject tayo kasi na ti adarebe nga namang Ted kini Grace. Iti sing-sing nga diamond. Tapos, ni Grace ti mang-receive ka DJ.
I will discuss the duty of debtor, obligor in obligation not to do. Number 3. To bear the expenses of having some else undo what has been done that is forbidden. Article 1168. Kapag ang isang obligasyon ay nangangahulugan ng hindi paggawa at ang may obligasyon ay ginawa ang pinagbabawal, ang may obligasyon ay may pananagutan na ibalik sa dati ang kanyang ginawa. The duty of obligor is to abstain from doing. The very obligation is fulfilled in not doing what is forbidden. Example: Christina bought a land from Brian. It is stipulated in the contract that Brian will not build a fence on a certain portion of his land adjoining that sold to Christina. If Brian constructs a fence in violation of the agreement, Christina can bring an action to have the fence removed at the expense of Brian. Number 4. To pay damages if guilty of fraud, negligence, delay, or contravention of the term to the obligation. Article 1170. Ang mga nagsasagawa ng kanilang obligasyon na may kasalanan ng fraud, negligence, o delay o balam, at sa mga nagsasagawa ng kanilang obligasyon na hindi ayon sa napagkasunduan ay mananagot sa mga danyos. Fraud, a false representation of a matter of fact, whether by words or by conduct, by false or misleading allegation, or by conclaimant of what should have been disclosed that deceives and is intended to deceive another so that the individual will act upon it to her or his legal injury. Negligence, conduct that falls below the standard of behavior established by law for the protection of others against unreasonable risk of harm. A person acts negligently if he or she has departed from the conduct expected of a reasonably pretend person acting under similar circumstances.